Okay, so in March of 1852, the Missouri Supreme Court ruled against Dred and Harriet Scott. Judge William Scott said that times are not now as they were when former decisions on this subject were made. Since then, not only individuals, bless you, but states have been possessed with a dark and fell spirit in relation to slavery, whose gratification is sought in the pursuit of measures whose inevitable consequences must be the overthrow and destruction of our government. Under these circumstances, it does not behoove the state of Missouri to show the least countenance to any measure which might gratify this spirit, this dark and fell spirit that's out to destroy the government by attacking the institution of slavery. And then he goes on to say that slavery actually is a good thing. It's a beneficent institution that has raised the American Negro up above the miserable African. We are almost persuaded that the introduction of slavery among us was in the providence of God, who makes the evil passions of men subservient to his own glory, and a means of placing that unhappy race within the pale of civilized nations. So it's a good thing, and it's a good thing for Dred Scott that he's not in Africa, because now he's a slave in Missouri, which is a pretty good place, and he should stop complaining. So, yes? His legal reasons are that, they should have brought the suit when they were in Illinois. Time passed. Okay, the same point you raised earlier. I mean, that is the legal reason. They didn't complain when they were in Illinois or in Minnesota. Now they do. Now, so they lose on appeal, and Mrs. Emerson, by this time, as I said, is living in Springfield, Massachusetts, and she gets married again. She marries another doctor. And this doctor, Dr. Charles Chaffee, actually is elected to Congress in 1854 as a free soiler. So, against the spread of slavery, and it comes up in the campaign. Well, wait a minute. This guy is against the spread of slavery, but he's profiting from the labor of these slaves in St. Louis. And Congressman Chaffee says, well, actually, it's my wife, not me. Kind of a complicated story here. And Mrs. Emerson, I said there was also this issue, who really owned them? Was it Mrs. Emerson? Was it her brother? And now she does sell the Scotts, probably because her husband says, you've got to sell these people because it's causing me trouble at the polls. She sells the Scotts to her brother John, who now lives in New York. He's an agent for the American Fur Company. Okay, so here you have John Sanford owns Dred Scott and Harriet Scott, and he collects the rent on their labor. The Scotts, meanwhile, have a new lawyer who takes up the case in St. Louis for them. And now they've lost in state court. But now the new lawyer argues they are owned by someone in another state, so they can sue in federal court because diverse jurisdictions, okay? And so here the argument is the Scotts are held illegally in slavery by someone who is a resident of New York. And in 1854, the U.S. Circuit Court for Missouri hears this case, and they find against the Scotts. Again, they say, had he been declared free while he was in Illinois, he would be free, so would Mrs. Scott, but having been declared slaves in Missouri, they're slaves. Okay? So, had they brought this up when they were in Illinois, yes, they'd be free, but they wait till they're in Missouri, and the Missouri court say they're slaves. So, the Scotts appeal, and as I said, it's not a big anti-slavery case. Making its way through the courts, it involves these two individuals who are not of very high standing anywhere. And finally, so none of the abolitionists stepped forward to take the case for the Scots being free because they had lived in free territory. Instead, they are defended by Montgomery Blair from a prominent Maryland family. He is the son of Franklin P. Blair, who was Andrew Jackson's chief journalist. Franklin P. Blair, and also a political ally of Thomas Hart Benton, one of the senators from Missouri. And Benton was aghast at the extension of slavery into the territories. As I said, one senator from Missouri, Davy Atchison, wouldn't allow Kansas to become a territory unless slavery were introduced. Benton opposed the Kansas-Nebraska Act because he saw this is going to divide the Union. Incidentally, a lot of people didn't like Benton because they saw him as kind of a grandstander, which he was. He also was very much against the extension of slavery into the territories. Anyway, Blair, Montgomery Blair, incidentally, Blair lives in Washington. Does anyone know where in Washington? Blair House, exactly. That's their house. Later on, they give it to the federal government, and it becomes the president's kind of guest house. Harry Truman lived in it when the White House was being redone back in the 1940s. So, Franklin P. Blair, a lawyer connected to Thomas Hart Benton, and connected to the whole Andrew Jackson thing. Remember, Jackson, Democrat, wasn't an abolitionist, didn't even think slavery was such a he owned slaves, but now the son of one of his aides or one of his allies is arguing this case for free. He knows the Scots don't have anything, and he is joined in this by George Curtis, who is a Massachusetts Whig, and Curtis's brother is on the Supreme Court. And John Sanford, he works for the fur company. He gets really good lawyers. One of them is actually Benton's successor as senator from Missouri, Henry Geyer, and Reverdy Johnson, another Maryland guy. Okay, so the case comes before the Supreme Court of the United States, and there are 4 points or 4 questions before the court. One is a very narrow question. Typically, when the court is trying to resolve a particularly contentious issue, it will look for the narrowest grounds on which to resolve it, knowing that if they make what appears to be a political decision, they're going to get into all kinds of trouble, and the court generally tries to avoid that. Okay, so first, is this a plea of abatement? If it's not a plea of abatement, the court would say, we can't decide this, and it would simply leave the lower court order standing. Okay, very narrow decision, which has the effect of leaving in place this lower court order, which said the Scots were slaves. Okay, second question. Are the Scots citizens? Are they citizens of Missouri, which means are they capable of bringing suit in federal court? Now, the Missouri courts had said, in some instances, yes, they have rights as citizens, but they're excluded from other rights as citizens. It's a relatively complicated issue. For example, women can't vote, but they do have rights in court. So no one would say women are not citizens. So are the Scots citizens? And then questions 3 and 4, is Dred Scott free because he lived in Illinois, which is a free state? Question 4, are both Scots free because they lived in Minnesota, which is free territory under the Compromise of 1820? Okay, so the lawyer for the Sanfords, actually Senator Geyer arguing for the Sanfords, says John Emerson wasn't a resident in Illinois, he was a sojourner there. He had not forfeited his rights of ownership, that he was there because he was an army doctor, not because he said, hey, I'm going to move to Illinois. And when he took Dred Scott with him, Scott's status was still governed by Missouri law. Okay? But Geyer takes it a step further, making an argument that actually Congress did not have the power in 1820 to prohibit slavery in this territory, because Congress's power over the territory meant only Congress's power to buy or sell land, not its power to govern the territory. Okay? Blair argued for the Scots. And remember, when the court is deciding an issue like this, the real issue for the court isn't necessarily what's in the best interest of Dred and Harriet Scott versus John Sanford. The real interest of the court is what's the constitutional issue here? Or what's the legal issue here? So Blair says the Territory Clause comprises 2 powers. One is this power to dispose public lands, and the other is to institute temporary governments to make needful rules for the territory. And Article 4 gives Congress the power to admit new states, and Geyer says this is an implied power. It's not an enumerated power, and you'll recall the grounds for Congress exercising an non-enumerated power is that the legislation has to be necessary or needful. You'll recall that's what Hamilton had said. And Blair says the distinction or the definition of what is needful is a legislative one, not a judicial one. That is, it's up to Congress to say what is a necessary power, not for the court to say this is necessary or this is unnecessary, because if the court does that, the court in effect is making legislation. Okay. And then Blair goes on to say that Calhoun and others had acknowledged that Congress does have power over slavery in the territory, because in 1850 they proposed extending the Missouri Compromise line to the Pacific, saying, okay, we'll have slavery south of it, we won't have slavery north of it. Well, how can you say you can't have slavery north of it unless you acknowledge that Congress can make that decision? And Senator Geyer says the Missouri Compromise, sorry to make this a debate between them, maybe next time I should bring in puppets to do different sides. Senator Geyer says the Missouri Compromise was essential to the survival of the Union, but the courts never said whether it was constitutional or not. And it violates the spirit of the Constitution by disparaging the domestic institutions of certain states and denying citizens equal access to the territories. And the power to restrict slavery is not expressly given to Congress. So, the arguments conclude, the courts begin considering an opinion to draft, and early in 1857, actually, it becomes clear what the opinion will be when it is learned that Chief Justice Roger Taney has assigned himself to write the court's opinion. Actually, the court writes 7 different opinions in this case, but we consider Taney's to be the opinion of the court, because 7 of the judges agree with Taney, or 6 of the judges agree with Taney, 2 dissent in this case. Okay. So, Taney says, he spends his most time on 2 questions that are before the court. One is the citizenship of Dred and Harriet Scott, and second is the power of Congress over the territories. Bless you. So, Taney, it's a fascinating decision for a number of reasons, and one is that Taney is using history to make his argument, okay? And so in answer to the first question, the citizenship status of Dred and Harriet Scott, Chief Justice Taney says they are not citizens. They cannot be citizens because the Constitution under which they are claiming citizenship was not written for them. At the time the Constitution was written, that is in 1787, they had, he's talking about blacks, had for more than a century been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so are so inferior that they had no rights which the white man was bound to respect, that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold, treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. Quite a, yes?
Well, I was just going to say that, doesn't that fly in the face of the fact that there were, I seem to recall that there were free blacks in Massachusetts?
There were, yeah. This is something that Justice... Yeah, that's right. This is something Justice Curtis brings up in his dissenting opinion, that this is flawed history. And it happens when you say something is fixed and universal, all you need to do is come up with one example to the contrary, which Curtis does. Is this a fixed and universal opinion? You don't need to look at Massachusetts. And incidentally, by this period, looking at Massachusetts was considered a suspect thing because those people were whacked. But think about James Madison, writing about the different aspects of people of color. In some cases, yes, they are slaves. In other cases, they're treated as people in the law. And in North Carolina, blacks could vote in this period. So is it a fixed and universal thing in the civilized portion of the white race? Well, what Tawney is doing, he knows what he thinks. And he's a civilized guy. He's a smart guy. And so he thinks everyone else must pretty much have thought like this. People of my situation in 1787 probably thought the same thing. And it's a mistake to do. So this is bad history, incidentally, as well as being an outrageous opinion. And then he goes on, the only two provisions of the Constitution which include them and point to them treat them as property and make it the duty of the government to protect it. No other power in relation to this race is to be found in the Constitution. And it is a government, as it is a government of delegated special powers. Again, this is the argument of the limitations of federal power that Tawney is applying here. No authority beyond these two provisions can be constitutionally exercised. The government of the United States had no right to interfere for any purpose but that of protecting the rights of the owner, leaving it altogether with the several states to deal with this race, whether emancipated or not, as each state may think justice, humanity, and the interests and safety of society may require. The states evidently intended to reserve this power exclusively to themselves. Okay? So, no federal power over slaves. And this includes slavery in the territories. So Congress's banning of slavery from the territories was unconstitutional, violated the Constitution. This is the second time in the history of the Republic that the court struck down an act of Congress. The first one was back in 1804 with the Marbury versus Madison decision. Okay, then, so Tawney makes the Constitution unambiguously pro-slavery. Remember, James Buchanan said, the court is about to speak on this, and that's going to settle everything. So this is a case where we have a big, contentious, violent issue before us, and the court tries to solve it all and settle everything down by coming down saying this is what the law is. And it doesn't bode well if you're anticipating solving contentious issues by going to court. And then Tawney goes on. He says the Constitution is pro-slavery. Congress cannot act except to protect slavery. And then he also cites the Declaration of Independence. It says, say, all men are created equal, but it doesn't really mean all men are created equal. He says blacks and free blacks really didn't count for this. This is something that sparks Abraham Lincoln writing a letter to a friend saying, we began our existence as a republic by saying, all men are created equal. Now we revise it to say, all men are created equal except Negroes. If the know-nothings get power, we'll say, all men are created equal except Negroes and Catholics. When that happens, Lincoln said, I will emigrate to someplace else, perhaps Russia, where I may take my despotism pure, without mixture with a base alloy of hypocrisy. So, Tawney says the right of property in a slave is distinctly and expressly affirmed in the Constitution, in language too plain to be misunderstood. Congress cannot prohibit slavery in the territories, nor can Congress authorize anyone else to do so. Okay? So it's fairly straightforward what Tawney and the court are doing. They're saying the Constitution allows slavery in the territories, so this means this political party which is just formed with the object of prohibiting slavery in the territories is arguing for something the Constitution prohibits. So what happens to the Republican Party platform in this case? Yeah. So why did they do that? Why did they not use the word slaves? Okay. So they wanted to leave it but here the future generation is deciding. Okay. We want to protect the institution of slavery because these guys protect it. I mean, Tawney is saying this is what all the white people thought in 1787. It's too clear to be misunderstood. I'm always wary when someone says something is too clear to be misunderstood.
But there were people in 1787 going around trying to...
Well, yeah, exactly. It's bad history, to begin with. Okay, so, this is an attempt to resolve this contentious issue through the judiciary, and it fails utterly. Okay, and it said that for years afterward, mentioning the Dred Scott decision in the Supreme Court was like mentioning the relative who was hanged at the family gathering. It doesn't solve things. It doesn't quiet things down. In fact, it triggers attacks on the court. We have this really curious thing. Tawney and Tawney was a Democrat. The Democrats never had great reverence for the Supreme Court. Remember, Jackson was always fighting with the court in the 1830s. And so the people who really liked the court were the Whigs. Well, now they've made a lot of the Whigs have migrated into the Republican Party. And they said one thing they didn't like about the Democrats was they were not beholden to the past and to precedent and so on. Well, here they have the court saying this is the law, and the Democrats are the ones defending this decision, saying we have to support the Supreme Court. And the Republicans are saying, well, wait a minute. Stephen A. Douglas loved Andrew Jackson, and all you have to do is remind Douglas, you can do it, doesn't really help you much, what Jackson had said when the court had ruled on the Cherokee Indians. They've made their decision, now let them enforce it. So it's a curious thing here.
Any reason to believe that Chief Justice Tawney sat down with Buchanan and sketched all this out?
No, there isn't any reason to believe he did this, but well, yeah. And actually, there are a lot of conspiracy theories floating around, okay? Henry Wilson, who's a Massachusetts politician, later on writes this book about the slave power conspiracy. And it goes beyond that, actually, that they're sitting down. I mean, you don't need to be a conspiracy theorist to do this. In 1858, there's a Senate election in Illinois. And Douglas is running for re-election. In those days, the state legislature elected the senator. And so there's a big contest in Illinois for this Senate seat. A little hesitant to bring this up. We're having a Senate election this very day in Massachusetts. And a couple of weeks ago at Suffolk, they did a performance of a play based on the Lincoln-Douglas debates. And it happened to be the night before one of the Senate debates here. And seeing the contrast between the debate of 1858 and a debate today was, well, a little sad, I think. But then again, they didn't have as contentious issues to deal with. So anyway, some of the Republicans in Illinois say, look, Douglas is now on our side. He has said no slavery in Kansas. He's broken with the Buchanan administration. Maybe we should support him. It's a plausible enough thing. Why not? And on the other hand, other Republicans, notably Abraham Lincoln, say, well, no, because Douglas is part of the problem. And in kicking off his candidacy, Lincoln has that wonderful phrase, a house divided against itself cannot stand. It will either be all one thing or all another. Okay? It'll either be all free. He says, I don't expect the house to fall, but I expect it to become all one thing or all another. It will either be all free or all slave. Now, he says, if you have, he goes on with this image of a house. Okay, if you have timbers cut by one workman, assembled by another, the finish work put in place by another, and the roof installed by another, even though they have never spoken to one another, but they have created a house perfectly, as though they were operating from the same plan, what conclusion can you draw but that they were operating from a plan? So let us suppose we have 4 workmen. We'll call them Stephen, Franklin, Roger, and James. And one tells us slavery is not a moral issue. We should leave it to the people of a territory to decide. And another tells us that the power of a master over a fugitive slave is absolute. And another tells us that slavery has to be allowed into a territory, and yet another tells us that slavery cannot be prohibited in a territory. What they're doing is tending toward creating a house where slavery will be the law. We will go to sleep tonight imagining that the people of Missouri on the other side of the river are about to abolish slavery. But what we will wake up to is a second Dred Scott decision, which tells us Illinois cannot prohibit slavery. You know, the Supreme Court has said Congress can't prohibit slavery. Well, how come a state legislature can then? Or how can a territorial legislature prohibit slavery if Congress cannot? And Lincoln says the Dred Scott decision does say the Republican platform is unconstitutional. Well, it also says the doctrine of popular sovereignty is unconstitutional. Because if your right to own a slave is absolute, how can any legislative body prohibit it? So it will become all slave. This is the way things are going. Lincoln begins that speech. Anyone recall the first line of the speech? If we know whither we have come, we can see where we are tending. So you can look at this path of things in the 1850s that has turned slavery into a national institution. And you'll see the end of this is going to be the establishment of slavery in Illinois and in Ohio and in Massachusetts and in Maine. Because how can you limit this if it is a fundamental right? If the right to an owner in a slave is absolute and cannot be checked by Congress or a territorial legislature, how can it be checked by a state legislature? So this is where we are going. And it's the Dred Scott decision that brings Lincoln out of retirement. He had tried politics in the 1840s, didn't do very well. He'd served a couple of terms in the Illinois legislature and then one term in Congress. And I think it is that experience that's convinced everyone else who has served a couple of terms in the Illinois legislature and a few years in Congress that he too not only can be president but will be a Lincoln. And he had left. He was now working as a corporate lawyer. But this is what brings him back into politics. Actually, there's another letter he wrote to someone in the early 1850s comparing his political career with that of Stephen A. Douglas. And in the early 1850s, Douglas was the man on the rise. He was the one who was going to become president. He was the little giant. And Lincoln said, we both arrived in Illinois at the same time. Douglas from Vermont, Lincoln from Kentucky, and he said, we competed briefly. Ever since then, his life, his career has been a glorious triumph. Mine has been a flat failure. But he re-enters politics in 1858, running for the Senate against Douglas and going around the state of Illinois debating in each congressional district. And the entire campaign is fought on the issue of slavery, the extension of slavery into the territories. So you asked earlier, in Kansas, were there any other issues in the Lecompton Constitution? Well, maybe, maybe not. But we do know the only issue in the Senate race in Illinois in 1858 was the Dred Scott decision and the extension of slavery into the territories. And in many ways, it is the most interesting constitutional debate since 1787-88. As you have two very smart people who really care about constitutional law, constitutional principles, arguing about the power of the federal government versus the power of the state governments over the issue of slavery. And Douglas says, I really don't care about slavery. If the people want it, fine. If they don't want it, fine. And Lincoln makes the point that, and Douglas says, I don't know if it is right or wrong. And Lincoln says, if slavery isn't wrong, then nothing is wrong. Very interesting campaign in 1858 in Illinois. Any questions on this? Yes, sir.
Sir, just go back to the Dred Scott case. This business of citizenship.
Yeah.
Was there any such thing as United States citizenship?
No, there wasn't, in fact.
You're a citizen of a state.
You're a citizen of a state, okay? In the 1820s, the court had made a ruling on what were the privileges and immunities of citizens of the United States. That is, things you enjoy, and they're relatively limited. because your fundamental rights are protected in the states. That's where you voted, that's where you owned property, and so on. Your rights as a citizen of the United States extended to using the navigable waterways, access to seaports, voting in federal elections, petitioning Congress, and if you really wanted to becoming a citizen of a state. Okay, so they're limited. Justice Washington, a Coriell case, it comes into play in the 1870s because it's in the wake of the Civil War that Congress proposes a constitutional amendment that does define who citizens of the United States are. So the Civil War, I'll get to answer your question in a minute, really is fought because of the Dred Scott decision. Okay, and after the war, part of the aftermath of this is answering the questions raised in this decision. Can the Scots be citizens? Chief Justice Taney said, no, absolutely not. The 14th Amendment says they are.
So Taney was saying that an African or a descendant of an African can never be
a citizen of a state. Because
no matter what state that
Congress because there isn't such a thing as national citizenship. This actually had come into question at the time of the Missouri Compromise itself, because the state of Missouri had tried to prohibit free blacks from moving in, but then people from the Massachusetts representatives said, well, wait a minute, that means free people from Massachusetts can't move to Missouri. And Madison had opposed this act on the part of Missouri just as much as he had the first part where Congress tried to prohibit slavery in Missouri. Yes, Ignacio.
And how does that affect those who live in a place like D.C.?
Excuse me?
How would that affect someone who lives in D.C.?
Well, in Washington, D.C., slavery is legal.
Even white people.
What do you mean?
Well, they only have one citizenship.
Yeah. So, the presumption is if you're living in Washington, D.C., you're a sojourner. Your residence will be somewhere else. Like Montgomery Blair actually lived in Maryland. He had a house in Washington, D.C. And there's good reason actually for not letting people in Washington, D.C. vote, because they're going to work, for the federal government. So that means essentially you're giving the federal government an additional vote. Glad someone raised this issue. Why people in Washington, the whole taxation without representation thing. We'll discuss this later on, I think.
But even somebody who was born in there
Yeah.
very limited powers, right?
Excuse me?
If someone was born in D.C. and lived all his life in
Yeah. Then he's not a citizen of a state. Under this doctrine, no, he's not a citizen of a state. So, too bad. They don't vote for president until the 1960s. Okay. You're from D.C., okay, yeah. See, Mike moved here so that he could enjoy the rights of a citizen of Massachusetts. Okay. So we have this big Senate race in Illinois, and actually more people vote for the Republican candidate than for the Republican candidates for the legislature than for Democratic candidates for the legislature, but more Democrats get elected, so Douglas is reelected. But the debates themselves are transcribed and printed up, and then Douglas goes on a speaking tour of Ohio, and Lincoln follows him, and the two of them continue this debate into 1859. And then in 1860, there's going to be a presidential election, and a very interesting presidential election, because what happens is this. Douglas, front runner for the Democratic nomination, as well he should be. The Democratic Convention, which met in Charleston, South Carolina, the representatives, the delegates from Georgia, Alabama, Louisiana, Florida, Mississippi say, you know what? The Supreme Court said slavery has to be allowed in the territories. So let's make it part of our platform that Congress has to draw up a slave code for the territories. Right? Because slavery can't be excluded, our right to own slaves has to be protected here. Also, we want a stronger fugitive slave law. All because people are resisting it more effectively by the end of the 1850s. Also require a 2/3 electoral vote for president as opposed to the simple majority. So a number of these issues, and Douglas doesn't think it's wise to introduce the prospect of a national slave code, because he knows this is going to lose the election in the North. And so the delegates from these states actually walk out of the convention. Won't have anything to do with Douglas The remaining delegates nominate Douglas for president and Herschel Johnson, the senator or congressman from Georgia, for vice president. So, they're trying to balance these two regions, but not calling for a federal fugitive slave code or a stronger fugitive slave law. The guys who walked out meet again in Baltimore, and they nominate their own candidates. Their candidate for president is John Breckinridge, whose job in 1860 was, anyone know? He's vice president of the United States, had been a senator from Kentucky. John Breckinridge and Joseph Lane, who's a senator from Oregon. Again, you have a balance of slave state, free state. And then the Republicans meet in Chicago, and there are a number of candidates for the Republican nomination, Lincoln being the most obscure of them, but he is nominated. So they nominate Lincoln, and anyone know who his running mate was? Hannibal Hamlin, thank you, from Maine. So two guys from free states, and then another party forms. It really worries, because these guys are saying those guys are advocating something that's unconstitutional. If they are elected through some fluke, that will show the rest of the country has broken the Constitution, and we will secede from this union, which has already seceded from us. Okay? So, those guys advocating something that violates the Constitution, they shouldn't even be on the ballot, which they are not in most of the slave states. Not that they would have gotten that many votes in Mississippi or South Carolina. Okay, so Douglas thinks these guys really are serious. Lincoln doesn't think they're serious at all. He thinks this is a big bluff. He thinks the calm, rational people will come to their senses. They want to blow off some steam, but ultimately they're not going to leave the Union. Now, there is another group that thinks these people also are serious about leaving the Union, and these guys are advocating something that's really wild and crazy and going to lead to all kinds of trouble, and what we need to do is save the Constitution and the Union, so they form the Constitutional Union Party. And their candidates are, you probably know these guys too. John Bell from Tennessee, congressman from Tennessee, had been Speaker of the House. Their vice presidential candidate was president of this institution. And he may have been the most notable man of the 19th century. First professor of classics here. He had been Secretary of State. He had been governor of the Commonwealth of Massachusetts. And in the 1850s, he had joined with the Mount Vernon Ladies Memorial Association to save Mount Vernon. He went on a national speaking tour because people would pay to hear him give his lecture, his oration on George Washington. Oliver Wendell Holmes said that people in Boston measure buildings by the Massachusetts State House, measure land by Boston Common, and measure men by... His greatest accomplishment is in 1863, he was invited to deliver the oration at the dedication of a national cemetery in Gettysburg, Pennsylvania. Folks in Gettysburg, it's July, they have this big battle. Tens of thousands of people are dead. They need to bury them to prevent public health disaster. So they say, let's have a cemetery right here. They want to bury them quickly. They ask this guy to give the oration. He says, okay, I can prepare and memorize an oration by November. So that's when we'll have the dedication. And he does. 2.5-hour oration delivered in November of 1863. Vice presidential candidate of the Constitutional Union Party, and no one remembers him. Edward Everett, thank you. They don't win. Okay. Now, during the course of this campaign, Douglas thinks if somehow Lincoln wins, these guys are serious about leaving the Union. Okay? And he realizes midway through that Lincoln actually is going to win because Lincoln carries all of the free states, which gives him a majority of the electoral votes. that is 180 electoral votes, which is exactly what you need to be elected president. He gets about 39.8% of the popular vote. Okay? Douglas gets 29% of the popular vote, but only carries 2 states. Well, he gets electoral votes from 2 states, Missouri and New Jersey. Breckinridge, 18% of the popular vote, and he carries 11 states. And John Bell and Edward Everett carry 3 states with 12% of the popular vote. Okay, so once it becomes clear that Lincoln will become president, the southern states start calling conventions to secede from the Union, beginning with South Carolina and Mississippi, knowing that on March 4th, this guy advocating this unconstitutional position will become president of the United States. We take it then the Union is broken. We hereby rescind our ratification of the Constitution. And this does raise a couple of constitutional questions for us. Can states secede from the Union? Well, it's not in the Constitution. Of course not. The Constitution is not going to say, well, we'll do this until, they decide not to. It does say a more perfect union, which doesn't mean, something is more perfect. It doesn't suggest it's going to end at some point, not an end date on this. If a state cannot secede from the Union, who prevents a state from seceding from the Union? What are you going to do? What? The federal government. Okay. How are they going to do this? Take them to court? Okay, force is the only way you're going to do this, okay? So President Buchanan actually studies this issue, and in December of 1860, he sends a message to Congress saying, secession is not allowed. States cannot secede from the Union. But the federal government does not have the constitutional power to coerce them back into the Union if they've left. Senator Seward of New York says in response, I think the president has conclusively proved 2 things. First, no state has the right to secede unless it wants to. Second, the president has a duty to enforce the laws unless somebody opposes him. John Crittenden, who had succeeded Henry Clay in the Senate, introduces a series of compromise measures, okay? A constitutional amendment that will prohibit the federal government from interfering with slavery in the states and also in federal forts in slave states. A more vigorous fugitive slave law. A reinstitution of the Missouri Compromise line, allowing slavery south of the line, prohibiting it north of the line. And also, so these are some compromise proposals that Crittenden proposed. Knowing, these guys are upset because they fear the federal government's now going to attack slavery in the states. Well, a constitutional amendment that says they can't do that. What do you think? Would you vote for these? You're saying no. I suspected you wouldn't go along with these. What do you think the Republicans should do, like Lincoln or Seward, who's a senator from New York? Show that they really want to save the Union by voting on these compromise measures. In fact, the amendment proposed allowing slavery does pass Congress, and it is the only constitutional amendment submitted to the states with the president's signature, because Buchanan thinks this would be a really important thing. Also, some states try to show their faith with these guys who are disgruntled and leaving the Union. So Maine and Rhode Island both had passed personal liberty laws. They repeal those to show, okay, we'll concede that people in our states don't have personal liberties because that prevents them, if they happen to be fugitive slaves, from being sent back to slavery. Okay. In February, about a month or so before the inauguration, a group of 21 states actually send delegates to a peace conference in Washington to try to resolve this crisis. As you now have a series of states seceding, South Carolina, Mississippi, Florida, Alabama, Georgia, Louisiana, and Texas have all had conventions saying we are leaving the Union, and this peace conference convenes in Washington. the same day a convention of these seceded states meets in Montgomery, Alabama, to draw up a constitution for the Confederate States of America. Back at this peace conference, former President John Tyler presides, and also in attendance are former Presidents Van Buren, Pierce, and Fillmore. And incidentally, this is the only time, I believe, in the history of the nation that a group of former presidents has gotten together to do something, other than to extol the virtues of Sprint or, attend a funeral or, I suppose Presidents Clinton and Bush did do hurricane relief, okay, but nothing domestically, typically. And former presidents never tried it again. They really can't accomplish anything at this peace conference. The same day they are meeting down in Montgomery, Alabama, the seceded states draw up a constitution, and they elect Jefferson Davis, a former Secretary of War and senator from Mississippi, and Alexander Stephens, former Whig congressman from Georgia, president and vice president. And they have a constitution which guarantees the sovereignty of the states, the right to property in Negroes, and a 6-year term for the president. Otherwise, pretty much like the U.S. Constitution. And these guys will maintain that they actually are following what the Constitution intended. In fact, on the seal of the Confederacy, anyone know what's on the seal of the Confederacy? Or I should say who? Someone on a horse. George Washington on a horse, yes. But state sovereignty and protection of slave property, that state sovereignty thing will run into trouble once the war starts. Okay, meanwhile, Lincoln arrives in Washington secretly. He has to be snuck through Baltimore because Baltimore's in the hands of the Democratic mobs. And Lincoln comes by train, and in Baltimore you have to get off the train on the north side of town to get onto the train in the south side of town. He's snuck through, and he arrives in Washington and delivers his inaugural address. And it's one of the notable addresses with which we all should be familiar. This one is his second one, which we won't get into tonight, unless you want to stay till midnight. I mean, I'm happy to stand here all night talking about Lincoln. But the first part of it is very much the speech of a very good contract lawyer and constitutional theorist. And it's really addressed to the people of the slave states which have not seceded: Virginia, Kentucky, Maryland, Missouri. And he's not necessarily interested simply in these states, but in the Union. And he believes that the people in these states are also interested in the Union. And the Union, Lincoln says, is perpetual. Perpetuity is implied, if not expressed, in the fundamental law of all national governments. It is safe to assert that no government proper ever had a provision in its organic law for its own termination, something you brought up earlier. So continue to execute all the express provisions of our national Constitution, and the Union will endure forever, it being impossible to destroy it except by some action not provided for in the instrument itself. The Union, he says, is older than the Constitution anyway. He looks at the Articles of Association of 1774 between these rebellious colonies. And then this relationship was matured and continued by the Declaration of Independence in 1776. That wasn't done by the states, but by delegates of the people in the states. The states, he maintains, never had an independent existence outside of a union of these rebellious colonies. And then finally, the Constitution, which, as he says, was designed to create a more perfect union. Well, how could it have been more perfect than it was before if now it has this element of, it's lost the vital element of perpetuity. So no state can get out of the Union lawfully. This is very much similar to what Jackson had said in 1832 about the tariff and about nullification. Okay? Perhaps something that Van Buren should have remembered. And he also says that the evils that these rebels are fleeing from are imaginary. All profess to be content in the Union if all constitutional rights can be maintained. Is it true that any right plainly written in the Constitution has ever been denied? I think not. Think, if you can, of a single instance in which any plainly written provision of the Constitution has ever been denied. If by the mere force of numbers, a majority should deprive a minority of any clearly written constitutional right, it might, in a moral point of view, justify revolution. Certainly would, if such a right were a vital one. But such is not the case. All vital rights of minorities and of individuals are so plainly assured to them that controversies never arise concerning them. No organic law can ever be framed with a provision specifically applicable to every question. No foresight can anticipate, nor a document of reasonable length contain express provisions for all possible questions. Shall fugitives from labor be surrendered by national or by state authority? The Constitution does not expressly say. May Congress prohibit slavery in the territories? The Constitution does not expressly say. Must Congress protect slavery in the territories? The Constitution does not expressly say. From questions of this class spring all our constitutional controversies. We divide upon them into majorities and minorities. If the minority will not acquiesce, the majority must, or the government must cease. There is no other alternative, for continuing the government is acquiescence on one side or the other. If a minority will secede rather than acquiesce, they make a precedent which in turn will ruin them, for a minority of their own will secede from them whenever a majority refuses to be controlled by such a minority. Is there such a perfect identity of interests among the states to compose a new union as to produce harmony only and prevent renewed secession? The central idea of secession is the essence of anarchy. So, a majority is held in restraint by constitutional checks, changes in popular opinion, and this is the only true sovereign of a free people. Whoever rejects it does of necessity fly to anarchy or despotism. The rule of a minority is wholly inadmissible as a permanent arrangement. So rejecting the majority principle, anarchy or despotism is all that is left. The chief magistrate derives all of his authority from the people. They have conferred none upon him to fix terms for the separation of the states. The people themselves can do this if they choose, but the executive has nothing to do with it. His duty is to administer the present government as it came into his hands and to transmit it unimpaired by him to his successor. Okay. In your hands, my dissatisfied fellow countrymen, and not in mine, is the momentous issue of civil war. The government will not assail you. You can have no conflict without being yourselves the aggressors. You have no oath registered in heaven to destroy the government, while I have the most solemn one to preserve, protect, and defend it. This actually is echoing Jackson's statement in 1832, and Lincoln knew this, that this was what Jackson had said. Okay? And then the final paragraph, which actually harkens back to something Madison had written in 1787. Hearken not to that unnatural voice which tells you the people of America, knit together as they are by so many cords of affection, can no longer live together as members of the same family, can no longer be fellow citizens of one great and flourishing empire. This is Madison, okay? No, shut your ears against this unhallowed language. Shut your hearts against the poison which it conveys. The kindred blood which flows in the veins of American citizens, the mingled blood which they have shed in defense of their sacred rights, consecrate their union and excite horror at the idea of their becoming aliens, rivals, enemies. And if novelties are to be shunned, believe me, the most alarming of all novelties, the most wild of all projects, the most rash of all attempts is that of rending us in pieces in order to preserve our liberties and promote our happiness. Okay, so Lincoln's conclusion, I am loath to close. We are not enemies, but friends. We must not be enemies. Though passion may have strained, it must not break our bonds of affection. The mystic cords of memory, stretching from every battlefield and patriot grave to every living heart and hearthstone all over this broad land, will yet swell with the chorus of union when touched, as they surely must be, by the better angels of our nature. So that's it for tonight.